Hello. I just sent you a text.
I got it. I
Okay.
was just about to text you the link.
Uh, Thank you. Because I want to transfer this to well, maybe I won't.
Okay, I think we are live. So, good afternoon, everyone, and welcome to the subcommittee meeting for the Public Safety Subcommittee of the House Judiciary of the Maryland General Assembly. I am Chair Nicole Williams, and we have, well, one bill and then a group of bills that we will be taking up today. And so I think what we'll start with first is House Bill 281, which is sponsored by Delegate Embry, and who is here. And I don't know if we have anyone in the waiting room that is here for House Bill 281. I think I was looking for Elizabeth Hilliard from the Office of the Public Defender, as well as Debbie Feinstein from the State's Attorney for Montgomery County. Hi, Delegate Embry. Yes.
Thank you. I can only speak for Debbie, but she was unable to be on camera because of a pre-existing appointment. But I have information from her if necessary.
Okay. Okay. All right. That sounds good. Um, so all right. So I guess okay, so she's here. I don't see Miss Hilliard. I don't know. Okay. But for members of the committee, I don't know if you remember this bill. This is House Bill 281, which is the admission of out-of-court statements for assault in the second degree. And we heard this bill probably about a month or so ago. Oh, Ms. Brownlee is here from the Office of the Public Defender. Okay, great. Delegate Embry, do you want to just give us a summary of the bill just to refresh everyone's memory about what this bill does?
Thank you so much. So under current law, there's a concept called forfeiture by wrongdoing. And for any felony case in Maryland, if either party causes a witness not to be present through bad acts like a threat, then outside of the trial, the standard is a preponderance of evidence. The judge can allow the statement of that person who has been kept away into the trial if the statement meets the definitions, like a recorded statement or a statement that they've signed. And so this bill, so again, that's current law for all felonies. It's also current law in the majority of states in the federal rules. But this would expand it to second degree assault. And the purpose is primarily because that is the majority of domestic violence cases. That is the top charge for those cases. And so that is where this problem is also seen, where not always the defendant, but often the defendant will cause a victim or witness, usually the victim, not to be there by threatening or in some manner the victim and telling don't be in court, or if this will happen. It could be violence, it could be, you want to have access to the kids or any number of things. It is rare, I will say, to have that evidence because if the victim just doesn't show up, then there's no evidence, nothing to do. But in the rare cases where you do have, for instance, a jail call or maybe a witness who saw the threat, this would at least allow a pathway for the prosecutor.
Anybody else?
Sorry.
The sound?
Oh, I'm sorry.
No, I can hear just fine, Delegate Simpson. You're muted now.
Lost her sound.
Oh, can you hear me now? Oh.
Yes. Yeah, I was hearing Delegate Embry just fine, but
I heard her up until about a couple seconds.
Okay.
I heard her, and then her mouth was moving, and I didn't hear. So
okay. Well, sorry about that. Delegate Embry, if you could just repeat the last little bit you were saying there at the end.
Yeah, absolutely. And I think I was repeating myself at the very end, which is just to say this expands the principle that exists for felonies to second degree assault. Thank you very much.
Problem.
Delegate Embry, you did say one. I'm sorry, Madam Chair, may I?
Yes.
Yeah, Delegate Embry, you did say something about this is not a frequent occurrence.
Correct.
Could you explain that?
Yeah, so you would need evidence. And the most common, the way that this usually plays out is if a victim is threatened or believes something bad will happen, and they just don't show up. They don't tell the prosecutor, they don't come to court. And so there's no evidence that of wrongdoing if it existed. So this would be in the circumstances where, often it is a jail call because those are recorded, where there is actual evidence, because the prosecutor has to prove by preponderance of the evidence that the other party and the defendant in this scenario had caused, through, bad actions, caused the victim or witness not to be there.
Okay. Are there any other questions for Delegate Embry? I know I have a few, but I just wanted to. Okay. So Delegate Embry,
Yes.
you mentioned that there are other states that does this, not just for felonies, but also for misdemeanor cases. Do you know roughly about how many states also do this for misdemeanor cases as well?
Yes, Debbie Feinstein sent me that. Let me look. I'm sorry if you don't mind. I'm
Okay.
just checking what she sent. She sent that. So she said every state that she was able to find, this in statute. It was over 26. They don't delineate, so they just provide it regardless of what the charge is. She says also in states that haven't codified, some courts using common law arrive at the same place through using equitable relief.
Okay.
So she said she saw it's 26, at least 26 codified, and the federal rules, federal law, and other states have common law principles that are similar.
Got it. And I see Ms. Feinstein is on now.
Oh, perfect. Well, then I won't
If you want to go ahead, Ms. Feinstein, that would be great.
So I will do my best. I'm sorry, I'm just not in a great spot to be online.
Okay.
So I'm so sorry. So I did a sort of a deep dive on the state-by-state analysis, and I was able to find, basically I found several law review articles, as well as some other secondary materials that talked about forfeiture by wrongdoing. What the secondary materials described is vast majority of the states have this either codified or it's a part of their common law, where it's basically it's using equity and saying basically that you can't rely on, you can't preclude testimony if it's been procured by wrongdoing, because that wouldn't be fair. I did not have time to sort of dig deep into the case law of the remaining 24 jurisdictions that didn't have it prescribed by either a rule or a statute. But again, this article tells me that vast majority do have this this principle in place. And what's even more telling is that the Supreme Court has adopted this, not just for felonies, not just for second-degree assault, but for all cases, because again, and it's specific in Davis versus Washington, where they talk about forfeiture by wrongdoing. It says you really, this would be allowing someone to do bad acts in order to procure a witness's absence, and then being able to essentially profit or benefit from that wrongdoing. And so it basically the Supreme Court is telling us that's not okay. And Maryland unusually actually did this carve out where it only applies to felonies. I did not see that in a single other state that I looked at. Every other state either adopted the federal rule or something almost identical to it, either in a statute or in a rule. Again, did not carve out misdemeanors, did not carve out felonies specifically. It applies to everything, because frankly, it doesn't make sense to say, look, if you commit this crime, then you can, procure the absence of a witness. I think another point that's important to note about the way that our statute functions, it's not just any statement of the victim that would, assuming that it's the victim, it's not just any statement of theirs that would be able to be used in evidence. It can only be a statement that was given under oath, subject to the penalty of perjury, or at a trial or a hearing or at a deposition, if it was reduced in writing and signed by the declarant, or if it was recorded in substantially verbatim fashion by stenographic or electronic means contemporaneous with the making of the statement. So it's not just sort of any random statement that a person makes that can then come in. It has to be in one of these more trustworthy formats, which again points to why we're able to use this, and how Maryland has set up some guardrails. But the guardrail of just having it apply to felonies really, frankly, just from what I've read, doesn't seem to make a lot of sense. And we're the only ones that are doing it.
Okay. And I see the Office of the Public Defender. I guess you have a comment, and just one question, which may get to what your comment might be. So thank you, Ms. Feinstein. I appreciate that information. One of the other questions that I had was one of the things that came out, I think it came up more so on the Senate side than on our side, had to do with the standard used with regards to the admissibility of the evidence. And so in the statute currently for felonies is based upon a preponderance of the evidence. And there was some, I think, conversation that was hinted at during our hearing in the House about the standard, I guess, being at one point, I think was, well, I sort of remember this bill. This is my very first year here on judiciary when we had the previous version of the bill. So I kind of remember when we first did this to lower the standard from clear and convincing to preponderance of the evidence back in 2020. And I know that was a comment that came up. And so I don't know if you wanted to speak on that, Ms. Feinstein, and I'll come to you, Ms. Brownlee, as well afterwards.
I'm happy to speak to that. I did look into that piece as well. Every state that specifically delineates has preponderance of the evidence, and I suspect that's why in 2020 Maryland changed it to preponderance of the evidence. That's also the federal standard and the standard that's laid out in the Supreme Court case law. And the other piece, which I did a little research on this morning, is that all evidence is subjected to a preponderance of the evidence standard. That's the general thing, and that's in Maryland case law. It's not unique to this particular piece of evidence. Again, I'm not sure why we're saying that there has to be a higher standard for this type of evidence as it applies to misdemeanors. It doesn't, again, it just doesn't make a lot of sense the way that Maryland has carved this out. Only felonies, and then again, the preponderance of evidence is the standard. And I looked at sort of what do the courts review it. It's an abuse of discretion. So the court, so essentially there's these rules that for all of the sort of admissibility of evidence, and it's all preponderance of the evidence. Sorry if I just repeated myself a little bit. Yeah,
it's okay, and that applies even to because this would be an exception to hearsay, basically, and even with
all exception to hearsay. Yeah.
Okay.
Yeah, like if you're trying to get in like a business record, or you're trying to get in an excited utterance or a statement against interest, all of those use preponderance of the evidence standards in Maryland. So again, why we're calling out this is something different. Look, all evidence that the state's going to present against a defendant is going to be prejudicial. And that's why there are these parameters, preponderance of the evidence. It has to be more likely than not. But then it goes to the jury to consider the weight of it, but it shouldn't be a barrier to admissibility.
Got it. Okay, Ms. Brownlee, you had your hand up. I think you wanted to make a comment as well.
I did, thank you. So my background with the public defender, I'm a felony trial attorney, but I'm in a small office. So I've got everything from murders down to driving while suspended on my dockets. So my immediate practical thought on this is how is this going to work? Because if you're adding in second-degree assault, now we're bringing it down to this is applicable in district court. So are we going to, in the midst of our busy dockets, now we're going to have little mini hearings within hearings to do these kinds of cases? And I would note that even if that's the case, if you look at the way it's written, it says, before admitting a statement under this section, the court shall hold a hearing outside the presence of the jury. So now then, additionally, I have an interpretation question. Does that mean that doesn't apply to district court? Does that mean that needs to be amended? Because right now it says that's only in jury trials, which makes sense if you're talking about a felony, because a felony is not something, with a few exceptions, such as theft, is not something that's within the jurisdiction of the district court. So it's not otherwise an issue. It's going to be in circuit court. So that's my practical concern. The other concern I have is that while it may be the case that Maryland has a very restrictive hearsay statute on this, Maryland also, I believe what I heard from the third-degree assault hearing is Maryland has the most restrictive second-degree assault statute on the books with a penalty of 10 years for something that could look like punching somebody in the face all the way down to I threw water at you. And that's certainly concerning when you're talking about now we're adding in that you can use for that second-degree assault charge, again, which we have, my understanding is we have the highest penalty in the nation for something in the neighborhood of second-degree assault. You're going to say that now you can use that in these cases. I'm here to tell you as a practitioner, if that's added in, I'm going to have those little mini hearings within hearings in district court, and you're welcome to reach out to me, but I potentially see a lot of havoc from that, but I'll do it because you are talking about something that carries 10 years. So those are just my concerns on the ground, how that looks.
Yeah, and I think maybe the practical piece about the jury trial is real, because you're right, in district court, you're not going to have a jury trial. That's going to be a bench trial. And so, but I guess my other question, and I do see your hand, Delegate Embry, is, you know, in the jurisdictions where they do this across the board for all misdemeanors, not just second-degree assault, wouldn't they have to go through that same kind of evidentiary process and having that many hearings? I guess that's my question. I don't know, Ms. Feinstein or Delegate Embry, anyone can answer.
I'll defer to the delegate, of course, and if she wants me to add, I will.
Thank you. Yeah, I just wanted to say, I'm having done a lot of cases in district court. All motions in district court are considered by the trial judge. That's the way it works. And pretrial, mid-trial, still they manage to be efficient. Also, the issue about out of the presence of the jury, I think I understand Ms. Brownlee's point, but they're bench trials in circuit court. So it's not that it's out of the hearing of the fact finder, it's specifically the jury. So it would operate really the same way as it would in circuit court if there were a bench trial. There it doesn't need to be out. I mean, it's out. There is no jury, so it would be outside their presence by default. So I think it would operate just in district court, just like every other motion to exclude. Thank you.
Yeah, and the jury part, that's existing language in the law currently. It appears that's not anything new. Okay. Okay. I feel like I'm asking a lot of questions. Are there any members that Delegate Conway?
Thank you, Chair. In reference to the motion to exclude, if a person doesn't have an attorney with them, they're representing themselves, they might not know to make the motion to exclude. Would that be correct?
That's correct. Just like every other available legal argument. That is correct.
Okay. Thank you.
All right. Do any other members have any other questions? Okay. I don't see any hands. Okay. Okay, I don't see any other hands. I guess I'll entertain a motion on this unless.
I would move favorable.
Okay, is there a second?
Second.
Okay, thank you, Delegate Pastor. It's been properly moved and second. Is there any further discussion on this? I mean, I know this is changing, you know, modifying the statute. Like I said, I remember when we modified the standard of review back in 2020, and it was to bring in out-of-court statements because there was a concern across the state about witness intimidation and witness tampering. And, you know, I agree, Ms. Brownlee, that this can go as low, you know, with a situation where it's just a bar fight. I mean, that's a second-degree assault, you know, and maybe we do need to also take up Delegate Moon's bill to add in a third-degree assault charge, which is before the committee. And so I do definitely see your point there about, you know, this isn't just about domestic violence. So that is part of the equation, but it would apply to all second-degree assault charges. I think the problem from a practical standpoint is our judiciary system, when they just charge second-degree assault, and you don't necessarily see that it's domestic violence related or not until you start actually hearing the actual trial from the actual witnesses. So,
So Madam Chair, if I could,
yes,
I asked Delegate Embry a question about its application and how often and where it would be applied and what would be required. That to me is the balance with this particular piece of legislation. It seems very limited in application, and so therefore, that is why I am moving favorable on this bill.
Okay. All right. I don't know if Michael is here. I don't necessarily have my little sheet here. All right, so I guess we'll go ahead and call the roll. I don't have my official thing in front of me, so I'm just gonna go. Actually, you know what? This is what I'll do. I have my thing in front of me. Let's do it this way. Wait 1 second. Oops. Okay, so we'll start. All right, I'm gonna take the roll, and if you can just either say yay or raise your virtual hand, that'll be great. Delegate Conway?
No.
Okay. Delegate Crutchfield?
Yes, because it's a very limited purpose that the exception will be used.
Okay. Delegate Ngola, did I pronounce that correctly?
We're close enough. It's Congolo.
Congola. I'm gonna get it. I'm gonna get it, Delegate Congola.
No, for me.
It's a no for you, no problem. Okay. Delegate Pastor.
Yes.
Okay. Delegate Phillips.
Yes.
Delegate Schmidt.
No.
Delegate Simpson.
Yes.
Delegate Taylor.
Yes.
Delegate Tolles. Delegate Tolles. All right. Delegate Tomlinson has an excused absence. Delegate Valentine has an excused absence. Delegate Tolles.
Request to call the roll, please.
Okay.
Conley.
And I vote aye. I vote yes, sorry, Williams. Okay, so that is 1, 2, 1, 2, 3, 4, 5 yeses and 3 noes. So the measure passes. Okay. All right. Well, thank you very much, Delegate Embry, for being here this afternoon, and for thank you, Ms. Feinstein and Ms. Brownlee, for being here as well.
Thank you so much.
You are welcome.
Thank you.
You're welcome. Okay. All right, next up we have, and I'm just going to take them together as a block of bills. We have a number of bills that are before us today, which I'm just going to call collectively the squatting bills. So 2 of the bills are from Delegate Conway. We have House Bill 154 as well as House Bill 164. And then we also have Delegate Naraki's bill, House Bill 202, as well as Delegate Holmes's bill, House Bill 560. And I don't know if any of them are in the waiting room, but I guess we can let them in. And I think the advocates that may be here for this bill as well.
Chair Williams,
Yes.
does somebody have an agenda with the list of bills we're hearing today?
They're on the MGA website. I apologize if you didn't get that in your email. These are the only bills that are left for us to hear today. It was just House Bill 281 and then these block of bills with regards to squatting. Okay, you're welcome. Okay, so I see Matt Hill is here. I see Brian Alou is here, and Lisa May is here from the Realtors, and Kristen Downs is here as well. So thank you so much for being here, and obviously Delegate Conway is already here. So, and I figured what we could do, members of the committee, is at least have a conversation, because we do have 4 bills presented in our committee that are basically all on the same subject. And I realized as I was working on this over the weekend, we have a 5th bill on this matter that we will hear on March the 5th. House Bill 271 that is being sponsored by Delegate Addison deals with wrongful detainer actions. And so I don't know if we're in a place where we're able to vote on anything in particular today. But I figured let us at least have a conversation about these 4 bills. Maybe we'll come back after we hear Delegate Addison's bill on March the 5th, and figure out what's the best way forward. I also realized in the midst of all of my research and deliberations over the weekend, so as you know, as we heard, Delegate Watson's bill is cross-filed. I'm sorry, Delegate Holmes's bill does have a cross-file with Delegate Watson, but there are also several bills over in the Senate dealing with this same issue as well that are not cross-filed with any of the bills that we have here in the House. So clearly this is a concern across our state, given the large volume of bills that we have trying to attempt to address this matter. I think we definitely need to do something about this. And so that's where we are. So Delegate Conway, I see your hand if you want to go ahead.
Yes, I don't understand why we're not voting on those bills today.
Well, like I said,
I don't think that, I'm not in favor. I just want to express my opinion. I'm not in favor of holding these 4 bills, 4 or 5 bills until March the 5th. And that wasn't my understanding that was going to happen today.
I understand that all 4 of these bills were set for subcommittee today, Delegate Conway. I didn't realize until over the weekend that there's a 5th bill that will be heard in our committee that unfortunately I don't set the schedule for the judiciary, but it is set for us to hear the bill on March 5th. And so I don't know if it's fair to Delegate Addison for us to move on any of these bills when we haven't even heard her bill yet in the committee. But that's just my thought. Delegate Schmidt.
Thank you, Madam Chair. I'm in agreement. I mean, we can move these four or 5 bills, or 4 bills, I guess, and wait to see if there's any differences on that bill when it gets here. That's still almost 3 weeks away.
Okay, I understand your concern and I appreciate that. I will say all of these bills are different in a variety of different ways, yet all seeking to address the same problem. And so that is what is before us. That is what is before us. And I just don't know if we are in a position right now to vote on any of these matters, given, like I said, the fact that there is now another bill that we have yet to hear. And number one, number two, all of these bills have some overlap with one another. Delegate Conway.
Thank you, Chair. Can I make a motion that do we have the right to say whether we want to vote or whether we want to hold the bill? I mean, you have people that said.
I think as the chair, I have the right to say we're going to hold the bills.
Okay. Sure.
Okay. So that's what we're going to do. I mean, I wanted to at least have a conversation, but which I'm happy to do, but I am not entertaining a motion on any of the bills today.
So, Madam Chair, if
Yeah.
we are open to a conversation, as you've suggested, with all of the bills that have come before us, this issue of squatting is a real issue. The challenge that I have is all of the bills also do not take into consideration what I would consider due process.
Right.
And so they're all attempting to address an issue. The manner in which they address the issue, in my opinion, abridges the right of due process.
Right.
So I do think, maybe this is something even before we get Delegate Addison's bill over the course of the next week or so, if, the sponsors might get together and at least attempt to address that issue in some way. And maybe it's the punitive nature of defrauding people that we can address, even if we can't address the speed at which to get people out, right? To get around the
due process.
detainer process.
Yeah, I think I would agree with you, Delegate Phillips. All four of the bills that are before us do, I think, have very real concerns as it relates to due process, which is a constitutional concern, which is another reason, even if we were to vote on these bills, I would move to vote unfavorable as they are, unless they are amended because of those constitutional concerns. Delegate Conway and then Delegate Simpson.
Yes, thank you, Chair. Are there amendments on my two bills?
I don't have any amendments on your bill, Delegate Conway.
Thank you.
You're welcome. Delegate Simpson.
I am very interested in hearing what the chair has to say as to why we've brought these today and what we would like to discuss. And I see we have several people that are here, and I would like to hear what they have to say and digest on it. I can understand how it would be a lot of information and something that needs to be considered. I'm ready to take notes, so.
Okay. And I think taking notes as well is good. I mean, this is, like I said, a big issue that obviously we definitely need to address. I think all of the bills in front of us, like I said, has some constitutional concerns that we would need to address before any of them will be ready to receive a favorable vote. And I agree with Delegate Phillips' comment that maybe the bill sponsors can get together to try to address some of those constitutional concerns. But since we do have folks here, I'm going to start in no particular order.
Delegate Williams, I have
I'm
your
sorry,
hand.
Delegate Taylor. Your little hand is blending in the background with your
Okay.
picture. I'm so sorry.
No, thank you. I think we're moving forward, and maybe my question's irrelevant now, but I think after hearing the testimonies and our folks on the advocates on the call, I think it'll help us understand better why you feel like we need to hold the bill. So I just wanted to make that comment.
Sure, no problem. So I'm going to start with Matt Hill just because he's the first Brady Bunch box I see on my screen of the advocates. Like I said, I'm going in no particular order. So Mr. Hill, I know you did testify maybe someone from your organization did. I don't know if you physically were there, but if you want to express some of the concerns.
Yes, thank you, Madam Chair, members of the committee. So our concerns start with the concern that you raised and Delegate Phillips raised. And it's not just our concern. This is the Attorney General's concern. This is the Attorney General's Office of Legislative Counsel. This is their Consumer Protection Division. Taking the court out of the process is fundamentally taking someone's due process rights away, right? Notice and opportunity to be heard when the state is attempting to take away your property interest. And so we have deep constitutional concerns with these bills as drafted because they bypass the court. They make the sheriff, the judge, and jury over every property dispute. And I just want to emphasize the wide variety of disputes that arise in these cases. So there's roughly 3,100 wrongful detainer cases each year in the state of Maryland. The kinds of cases that we see legitimate defenses are one that's mentioned in my testimony. It's also highlighted in a Baltimore Banner article that I sent around to the subcommittee this morning. It involved a Miss Titkins. And what happened in that situation was that it's a rooming house with 6 or 7 elderly or disabled individuals, each renting a room. A new purchaser bought the property at sale, said, I don't know who these people are. I'm going to file a wrongful detainer. They're not my tenants. Now, they were tenants. They were paying rent to the old owner. And the law says that when a new purchaser purchases the property, they step into the shoes of the old owner. But this guy didn't know that. He said, they're not my tenants. I'm going to file wrongful detainer. That was the inappropriate action. The tenants were on the eve of being evicted. We got involved. We filed an emergency motion with the court. we were able to stop the eviction and work out a settlement. Now, if these bills had passed, any one of them, there would be no way for us to file an emergency motion. The landlord would go straight to the sheriff. The sheriff would say, okay, you're the owner. You say XYZ. You say this. Okay, we're going to do the eviction. That's the fundamental problem with these bills is, again, there's no court process. We also see this in the context of scams. So I quoted some numbers in my testimony, but just a huge number of scams. I think in 2018, it was 5 million of these rental scams in which some unscrupulous actor sees that a property is vacant for sale. They break in, change the locks, advertise it on Craigslist, Facebook. Some poor person who's desperate for affordable housing, because you all know how housing costs have risen in the past few years. They see it, they go to the property, they're shown around, they're given a key. They say, okay, give me $5,000 for your security deposit, first month's rent, or whatever it is. And they do, and they think that they're renters, right? Until 2 weeks later, they get a knock on the door from the real owner saying, hey, I own the property, not the guy you rented from, and now you need to vacate. And I'm not saying that person needs to stay there indefinitely by any stretch. They need to vacate. But what we don't need is the sheriff showing up suddenly without any court process and deciding whether or not this person is a legitimate renter or a victim of a scam who, you know, without a little more time is going to possibly become homeless because they have nowhere else to go because they just gave somebody their last $5,000.
Right.
And of course, who does this impact? We know that this impacts predominantly, disparately poorer Black and brown, particularly women who we see in this rental market, who are the most often those who are evicted first. I have a lot of other data, you know, and these scams too, I understand why time is limited. Property owners need to take some responsibility here. There's a lot of technology that can be used to secure properties. We're happy to work on the wrongful detainer process. So, you know, how long you get into trial, how long an eviction after trial. Are there some relocation assistance for victims of scams? Those to us are the appropriate questions that should be asked. We don't have any data. And so we'd really like to turn the conversation that way. Thank you.
Okay, thank you. Next, I'm going to go to Brian Alou. I know you testified in support definitely of House Bill 202. I can't remember if you guys were supportive of the other bills that are before us, but if you want to just give a brief remark with regards to the bills that are before us.
Yes, thank you. Brian Anlou with the Apartment and Office Building Association of Metro Washington, representing multifamily owners in Montgomery and Prince George's counties. And while I can't speak to the due process concerns, and I can speak to some of our concerns with squatting, it's not the traditional squatting that you might think of that I think Mr. Hill was just sort of describing with what happens more so with single family homes and single family rentals. But it's specific to like unauthorized occupants or subletting. So situations where you maybe you have a couple and one person who is on the lease decides they want to vacate the unit, and the person who is not on the lease decides that they do not. And what rights does that person then have to sort of have a claim on that unit? If the landlord decides they no longer want to continue the relationship, really with either party, or if there was, you know, if it says in the lease that you're not supposed to or are allowed to sublet the unit, but that's happening anyway, then, you know, what happens if the person who is the main leasee is evicted for whatever reason, and then the subletting party says, well, hey, what about us? We don't want to leave. And so, you know, what rights that person has. And so we view House Bill 202, and I think there's at least one in the Senate that AYOBA and our sister organization, MMHA, were supportive of with respect to these sort of different situations from what you all might think of when you think of traditional squatting.
Got it. Okay. But House Bill 202 is not cross-filed with any particular bill in the Senate. Is that correct?
It is not. We were particularly supportive of Senator Jennings, Senator Reedy's version over there. So as you mentioned, there's a few there's a lot of interest in this particular topic, some with overlap in both houses, but it was not.
Okay, thank you. Delegate Schmidt, I see your hand.
Thank you, Chair. I'm just reviewing the article of real property that was sent around. There's a bold paragraph on page 1 that talks about a hearing is scheduled. Under subparagraph of this paragraph should be held not less than 4 calendar days, not more than 7 calendar days. So when we talk about due process, I guess the purpose of these 4 bills or 5 bills now is really to work on due process at the end of the day, right?
Yeah.
You know, I had the luxury of being on the ENT joint hearing last year with the governor on the housing bill that discussed something like 14,000 evictions that were filed in Baltimore City just for calendar year, 2023, 2024, talking about how Maryland is #1 in evictions. And I heard Mr. Hill bring up 3,100 wrongful detainers. That number seems kind of low to me statewide if evictions are 14,000 just in Baltimore City. So the process that the landlord or rightful owner goes through, it's my understanding it starts with a wrongful detainer, then there's a process, then it leads to either eviction or some sort of ruling, whether the tenant can stay or negotiate the lease or what the terms are there. I mean, the goal at the end of the day is probably to eliminate the number of evictions that we have. That's the biggest concern that I believe the governor and his administration is attempted to work on, is why do we have so many more evictions compared to other states, right?
Right.
And I think it's our job as the subcommittee to work on the due process part of it, because I think every situation is a little different. Matt explained the situation, Brian explained the situation. I'm sure we could probably go through all 50,000 explanations of situations. Our job is to try to streamline the process for everyone that's involved. I mean, we do have situations where there's scams. We have situations where there's subletting. We have situations where someone vacates the property, and our job is to really narrow down how can we put something in the law that prevents the squatting side of it.
Yeah. And I think you're spot on, Delegate Schmidt. I think what you saw was that was something that was sent over, I think, a proposal from the judiciary who unfortunately couldn't join us today, about maybe some ideas of how to modify the wrongful detainer statute to expedite the process so it does move more swiftly. I think that's part of what all of these bills are trying to accomplish, is how can we get some type of expedited process to deal with these concerns. And so I think you're spot on, Delegate Schmidt. I know your background would be really beneficial in helping us deal with this. So I think, as subcommittee, I think we can certainly work through some of these issues. But I just don't think right now the bills are at that point to pass as is. That's all.
Yeah, thank you, Chair. And I can just tell you from experience, the reason we are seeing rapid rise in some of these rates is that a landlord, if they have a situation where they're going to court or they're vacant for a long period of time, what happens is they end up trying to recapture their rent for loss of income for whatever period that is. And the rapid increase, this rapid appreciation of rents is a major concern. And it's continuing to happen even today. And I'm sure the Maryland Realtors can give you some statistics. But a lot of it starts kind of with some of these processes.
Yeah, absolutely. Okay, so next, really quickly, I know we're short on time, maybe just in a few minutes. I see Miss May and Miss Dowles. So I'll go to Miss May and then Miss Dowles, and then we'll probably wrap up from there. And you're muted, Miss May.
I think I double tapped that. Okay, thank you.
There we go.
Now, from the Maryland Realtor standpoint, we certainly have sympathy. Those rental scams do exist out there where folks are tricked into thinking that they have a legitimate lease for a property. And we certainly have sympathy for that. But we also have another subset of folks who know our landlord-tenant laws in the state and who use those to their advantage to stay in a place where they know that they are present illegally. And it is trying to find a balance between all of those and to try to make the property owners whole as quickly and as efficiently as we can, because whether it is the leasing scam or whether it is just a true squatter, those property owners have been victimized and have had their properties taken from them illegally. So how we can do that, whether it is expedited detainer, that is a process that we have supported in the past. We just want to try to make people whole as quickly as we possibly can. So that's all that I have to add.
All right, thank you. And Ms. Downs.
Good evening. Thank you for letting me participate in this conversation. I think the testimony previously indicates just how complicated and varied this situation is, whether you have someone that's been scammed, whether you have a scammer that has been doing this, whether you have people who feel they have an actual lease. I think it just shows how this is something that's complicated, but something that is well outside of the purview of the sheriffs to sort out. All of these bills, in essence, take this analysis and put it in the hands of the sheriffs to make very quickly and to decide who's telling the truth, whose lease is valid, who has a promise, whether there was a relationship, because a lot of these happen when family member has let somebody live and then they're tired of the family member and they're trying to get them out. There's no paperwork. It really is not the expertise of the sheriffs to be able to figure this out. And so we would request that whatever happens in this case, and I do submit that this is a real problem and it has victims on both sides. And I feel that some of these bills are saying, because you're not a property owner, your rights are not as important. Because you are in a situation in which you need to have a roof over your head with your kids, that you have gathered all your stuff together in order to pay cash, in most cases up front. But that doesn't matter because you're not a property owner. And I don't necessarily think that that's where Maryland wants to be. And I don't think that the sheriff is in a position to sort that out. And so we would request that anything moving forward would understand just how complicated and how high the stakes are, and take that into account as we draft something to address this issue. I'd also just quickly want to bring up that, this is has really kind of elevated a physical identity theft. And we put a lot of things in place as a state in order to address the victims of identity theft. But this, as written, will do the opposite. It is actually criminalizing victimhood. And so I would just request that however the committee decides to move forward would keep those issues in mind.
Thank you. Thank you so much. And I think having the sheriffs as part of this conversation, I think is going to be important. Delegate Phillips.
So I have maybe a couple of questions. One is for those who are practicing in this area and actively engaged, what is the quickest you've ever seen the ability to get into court to deal with this issue? So if I think it was Delegate Naraki who explained he had a family who reinvested in a property, and it took them several months to get him out, and they lost a lot of money, right? They lost some of their life savings. Those are real. So what is the fastest today? What would be what you would recommend maybe dealing with the judiciary and trying to speed this up, which the judiciary doesn't like to be rushed, and people need to prepare for a hearing. But just talk about speed and timing today versus what we think we could get to. Anybody have a thought?
Downs, I saw you took yourself off mute.
I would let Matt answer that. He is probably more on the ground.
Okay, Matt.
I could share our experience from Baltimore City. We don't practice a lot outside the city at the moment. And talking with my other colleagues around the state, because we've been looking at these bills. We can, sometimes you can get into court within, say, 2 weeks from filing to trial in a wrongful detainer case. That's not unusual. Maybe it's 3 weeks at times. From our perspective, too, I just want to introduce, for the tenant, it's not only about from the time of filing to trial, it's from the time of service to trial, because they don't know when the complaint's filed. You don't know the complaints until it's actually posted by the sheriff and mailed by the sheriff. So there's no personal service in these cases. There's no hunting for people, right? All the sheriff does is post it on the property and put it in the mail. And the mail, unfortunately, as you all know, is not what it used to be.
Right.
And it can take a solid week, even if you're mailing within the same jurisdiction, to get from the sheriff to the property. And so our concern is to ensure there's some sort of requirement that people be served in a timely manner so that they can reach out to get an attorney. Because as you all know, Maryland has a right to counsel and evictions law. You helped pass that, you voted for it, and it's working. We're helping 88% of the folks who come to us to stay in their properties if they want to. But we need a little time. We need the folks to be able to get to us before court so that we can then help them prepare any defense they have, or tell them, hey, you don't have a defense. Either way, folks need a little bit of time to be able to get to us so that we can help them. And so that's one aspect of this.
So I guess I'm really concerned about those individuals. This is a balance, right? We've got, as I said in one of those hearings, sometimes you got bad people who just do bad things, i.e. they squat, right? They have no right to the property and they do that. And so these laws are really not focused on those individuals who are being taken advantage of, per se, or those individuals who actually have an interest in the property and you've got a bad landlord trying to get them out using the courts to do that. There are these other group of people who have made an investment or who legitimately don't want their property to get wrecked once they've told somebody to get out. So they know they've got a limited amount of time. I think that was Delegate Conway's point, right? They've got a limited amount of time before something really bad happens to their property. So I'd ask you all to think about this. How do we address this when we have a very limited period of time in some of these instances?
Yeah, good point. Good point. And I hear your point, Mr. Hill, about the service, whereas the statute requires posting and mailing, and maybe we could do a combination of all three, because the other issue is the speed, and affixing the summons to the property as well as mailing, in addition to an attempt at personal service, I think might help to deal with some of the due process concerns. But we also need to try to expedite this as quickly as possible in these situations is the other thing. So, just solely trying to attempt personal service might not get us there 100%. Okay, well, we're approaching 5 o'clock. I want to thank all of the members of the committee for being here and I think we have some work to do. So, we know that we have these bills in front of us. If people can just kind of noodle in their heads some of the things that maybe we can do to get these bills ready to deal with some of these constitutional concerns, I think would be great. But I think we will definitely revisit this issue because, like I said at the beginning, this is definitely a really huge issue that I think might just get worse, especially, we see these things exasperate whenever there's an economic downturn. And so, at least I know I've seen that in my jurisdiction when we had the foreclosure crisis back in 07 and 08. This was very prevalent during that time. With that, I'll entertain a motion to adjourn.
Motion adjourned.
Second.
All right. Thank you, guys. Thank you so much. Appreciate all of you all. Thank you.
Thank you.